All right, good morning.
Good
Can you hear me?
morning. You want me to ask the green button now?
I'll press it for you. You speak.
Yes, sir. I can hear you.
All right, I can hear Mr. Dupree.
Yes, sir.
Counsel, I can't hear you.
Me, Your Honor?
Okay, all right, and your name, please? I know you're Mr. Peters.
My name is Eric Peters with the Attorney General's office.
All right, sorry for the delay. I was trying to get a copy of the Supreme Court's order in this case, and I'm still looking for it. But let me go ahead and call the case. It's case number 2015 HC 45. It's Demetrius Dupree versus Clay Tatum, and it has a long procedural history. Mr. Peters, I'm sure you're aware of that. And my first question is, I have not seen anything from Floyd County pertaining to the record below. Do you have anything?
Yes, Your Honor. We have the Floyd County records.
What do you have, Mr. Peters?
I have the indictment and the final disposition, and I can share that on the screen if you would like.
Yes, sir. I definitely need to see it.
Okay, give me 1 second.
Now, that was a guilty plea in 2008.
Yes, Your Honor.
All right. Is there a transcript of the plea colloquy or?
No, all we have is the indictment and final disposition. Let's see. Can you all see that?
If I turn my head sideways, I can. Yeah.
Let me see if I can flip it. Here we go. Okay. So Demetrius Dupree, Floyd, 2008. It's the indictment. Let me know if I need to slow down or anything.
All right, could you stop it there?
Yes, sir.
All right, it looks like an acknowledgement of rights that Mr. Dupree signed, and then an attestation from the attorney that she went over her rights. Is Mr. Dupree able to see these documents?
Can you see him?
Mr. Dupree,
Yes, sir.
can you see those documents?
Yes, sir.
All right, I want you to take all the time you need to read through them and make sure they're accurate and they are what they purport to be. So I'm going to give you a couple of minutes to read through that, okay?
Let me know if you would like me to scroll around in the document so you can see the full thing, Mr. Dupree. The final disposition is also on this last page, just so you're aware.
And Mr. Peters, I'm trying to read that. Does it show count 2 is 15 years?
Count 2 is 15 years. Yes.
And then count 5?
5, 6, 7 is
Five?
5 years. a total of, I believe, 20 served 5.
I haven't been more than 5 years. It was straight 5, 125.
Excuse me?
That was a straight 5 sentence. 25. Yeah, it was 25, I think so. Pretty sure. But I know I paroled out on the same case. They speaking about recidivism. I paroled out in 2009 on the same case. I got locked up in 2008, and I paroled out on it in 2009. Because
Okay.
they non-process
All right,
recidivism.
Mr. Dupree, before you offer any testimony, I'm going to ask you to raise your right hand. Please raise your right hand. Do you swear or affirm that the testimony and evidence you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, and your name is Demetrius Dupree, is that correct?
Yes, sir.
And all we're doing at this point is showing you documents relating to the 2008 case. You don't have to give testimony at this point. We simply want to know if you recognize those documents, and we can get into what the correct sentence was. I have to admit, it's sort of hard to determine looking at the documents, but I'm trying to read through it.
Well, I know when I went down the road on this case, my counsel told me that the recidivism were non-process.
Hold on, sir. I don't want you to testify at this point because we've got several documents I want you to look at. First of all, do you recognize this to be the sentence, the guilty plea and sentence that was imposed in your case back in 2008? Do you recognize it?
Yes, sir.
And do you recognize your signature on that document? If you could go back to the
But see,
signature portion.
another thing, I was led to sign this.
All right, is
I
that
lit-
your signature? See that 18th of August, 2008?
Yes,
Is that
sir.
your signature?
Yes, sir.
Okay, all right, so the document does bear your signature, and I'm gonna let you explain it later, but hold off on that. Mr. Peters, do you have any other documents?
That's it, Your Honor.
Okay. And Mr. Peters, what is your position as to the procedural status of this case at this point?
I believe pursuant to the Supreme Court's order, we just need to admit these documents and then reissue a final order which addresses grounds 1 and 2 of the petition. So basically, they remanded the case and said that we need to introduce the documents and that the original final order did not address grounds 1 and 2 of the petition.
Yeah, and I acknowledge that.
So we basically just need to get the documents in and redo the order.
All right, and since I don't have the actual application for habeas corpus in front of me, what are grounds 1 and 2?
So in its order, the Georgia Supreme Court actually construed grounds 1 and 2 in one consolidated ground, and it said that the ground states that in post-revocation, the judgment as to petitioner's 2008 offenses had been impermissibly modified such that he is now required to serve the revoked portion of that sentence without parole as a recidivist.
All right.
And if you would like, I can state grounds 1 and 2 of the original petition too.
No, that's fine. That's fine. And what is your position as to the merits of that claim now that we have the 2008 documents before the court?
Well, it seems that he was sentenced as a recidivist on that 2008 case. So when his probation was revoked, it seems that Mr. Dupree learned about that, and that seems to be the gripe.
Okay. All right, Mr. Dupree, you're already under oath. I'm going to allow you to testify at this point, and we can do it you can testify about your documents. You can offer testimony in support of your ground regarding the recidivist sentencing. So you may proceed at this point.
Good morning, Your Honor. It's a
Good
pleasure
morning.
it's a pleasure to be found here today. I'm here for the case of Mitchell Dupree, and I'd like to state for the record that I'm not a licensed attorney. I'm a real party of interest. There are several points that I'd like to get on record today. One that would establish the fact that Dupree has had several of his U.S. constitutional amendments rights violated. By the Dupree is attained by authority of legal conviction and sentence. Before I say any more, I'd just like to say thank you for the opportunity today, Your Honor. This is about my fourth time being continuous on this case. It's been hard for me to get my case across without an attorney in the present. I filed a written questionnaire to my attorney to the Lions Court. And I ain't got no kind of response back. I sent like 56 questions for my attorney to answer, because he never could make it to the hearing since I've been in Hague. I filed for ineffective assistance and conflict of interest. And I ain't never been able to get across because the attorney never showed up. And this written question thing I filed, I never got a response back. I ain't got no kind of transcript on that. I got a letter saying that it's been sent to the court during the transcript. But I haven't received the deposition of transcript of my final disposition of my written question that I sent to a attorney, William Hilliard. I don't even know this attorney here. I ain't never seen him. I ain't never had it from my attorney. I don't know this guy. I don't know if he ain't never been my attorney. I don't know him. This is not my attorney.
What are you talking about? This is Mr. Peters is with the Attorney General's office.
Right, but I'm saying I need my attorney that was over my case so I can present my questions. And I can't go on with my case without presenting my case because he's a part of my case in effect the system and conflict of interest.
Did you subpoena him to be here today?
I subpoenaed him to be here about 3 or 4 times ago. Every hearing I had, I subpoenaed him. He never showed up. And the court said they tried to contact him, but they never could.
And Mr. Peters, if we could briefly address that, I do know that at the evidentiary hearing in this case, there was testimony offered, I believe, by guilty plea counsel or the revocation hearing in 2013. I think it was a guilty plea and revocation at that time. And there was testimony from his attorney who represented him in that 2013 proceeding.
Yes, Your Honor, I believe that's correct.
All right, but are you familiar with whether or not, I believe the woman's name is it Miss Walker? Was Miss Walker your attorney?
She was a backup attorney because Mr. Henderson had stepped out 1 week or 2 weeks for being sick in hospital, and she just stepped in, took his place until he came back. But she's not my attorney. She was just a fill-in attorney while he was out sick.
Well, the records show that she signed as your attorney.
Yeah, she was just an acting attorney, because my attorney wasn't there present. He was out sick at the time, and she, I guess they just wanted her to take his place until he came back. But she's not my appointed attorney. My appointed attorney is William Henderson. Bill William Henderson. That's my appointed attorney that I had for this case. And I haven't spoken to him since I've been incarcerated, even during the Hague.
All right, Mr. Peters, I'm here virtually. I don't have the record in front of me. I don't know who he's subpoenaed, who he hasn't subpoenaed. Can you assist the court with that information, or do you have it?
I'm not aware of any subpoenas for this hearing, but I do have the guilty plea hearing transcript, and it does show that Mrs. Walker represented Mr. Dupree at the guilty plea hearing.
Okay, so you do have that transcript. Are you going to submit that as part of the record?
I believe it was submitted as part of the first habeas corpus hearing transcript.
Well, that's the 2013 plea though, correct?
This is the 2008. So Mrs. Walker represented him in the 2008 guilty plea.
Okay, and that's already in the record?
Yes. Let me double check.
No, Miss Walker was just an attorney. She told me she was just an attorney that represented me while my attorney was
Okay,
out sick.
I've heard you, Mr. Dupree, I've heard you say that, but I'm going to have to rely on what's in the record.
Yes, sir. But my attorney, William Hills, was there in 2013 revocation. He was there, Miss Walker wasn't there. She was there in 2008, but she wasn't there in 2013. Mr. Henderson was there in 2013.
Yes, that's correct. Mr. Henderson represented him on the 2013 case, and then Mrs. Walker represented him on the 2008 case.
Ms. Purcell, you're there in
But
Tattnall County.
Mr. Williams was there
Are
for
you
me
familiar
in
with what's in
2008
the
case.
record?
Yes, Judge, let me check.
Please do.
I got 2 many attorneys on one case.
See, it's not, that's the problem, it's not, see, this is 2000. See, this is why precedence.
And Your Honor, this case has been put off about 4 times. Continue trying to get the attorney, Mr. William Bill Henderson, to show up in court so we can get this tough care. And so I can ask him questions. I ain't been able to, go on with my case because he's not
All right,
showing up.
We're looking into that right now.
So we need to get this.
He would tell you he was over my case in 2008 if I can just get him presented.
Your Honor, I don't believe we have the guilty plea hearing from the 2008 case in the record. So if you'll allow me a minute to scan this in, and we can introduce it now.
That was the whole point of, asking for that record. Okay, please do that. And Ms. Purcell, is that correct? There is no
That's,
complete colloquy?
that's correct. We need the 2008 transcript.
I thought so. Okay. All right.
Yeah.
Okay. Okay. Thank you.
And Ms. Purcell, are there any subpoenas in the file for a Mr. William Henderson?
I do not see any. No,
Well,
sir.
I had came to court one time for a hearing, and the clerk officer said that they was trying to contact him, but they never could, and they couldn't get no paperwork on my case at the time. So this continued. It's been like 2 or 3 times, and I got it continued one time, like about a month ago. on the same hearing.
I understand,
Um,
sir, you
And
said
I
that
asked the
several
court,
times. Mr. Dupree, if you'll just hold off, we're looking into it. Ms. Smith, we're trying to complete the record from 2008 as,
Yes, Your Honor.
as per the Supreme Court's direction.
And Judge, just for the record, Mr. Peters is scanning in the plea transcript from 2008. We also have that indictment that we were planning to tender this morning.
Right.
What was introduced at the 2018 hearing, I've got the transcript and I'm sure Ms. Purcell has it, is the indictment and final disposition for the 2013 case.
That's correct.
The plea transcript / revocation hearing in 2013, and then the deposition on written questions of Mr. Henderson. So Mr. Henderson's already testified. Mr. Dupree's already had his opportunity to question him. So it's just getting those 2008
I
documents.
hadn't had a chance to talk to him in court at all.
Okay, he doesn't have,
Court.
Mr. Dupree, I'm going to tell you this for the last time. He doesn't have to come to court. He was deposed. You had the right to send questions to him in writing, and that's been
I
done.
have done all
Sir,
that, but
sir,
I ain't got
listen.
I haven't gotten the deposition yet of the transcript.
All right, sir, what, if that's in the form of an objection, it's overruled. It is a part of the record. His testimony is in the record by way of deposition. So you did have a right to ask him questions in writing. That's been done. We're not going to
Yes,
bring
sir,
him.
I've done it. I've done that, but I haven't got no respond back on the outcome or what he said or about my question, nothing, you know.
All right, they're in the record.
Okay, well, can I get the records?
We're going to give you a copy of the record.
I need a copy of the record and the deposition.
Yes, sir.
The deposition, Mr. Henderson.
All right, Mr. Peters, do you now have the plea colloquy?
Yes, Your Honor. Give me 1 second to pull it up.
Once again, Your Honor, may I speak, sir?
Mr. Dupree, no, not at this point.
All right, let me know when I can.
I will.
Okay, can y'all see this document?
Yes, sir.
Okay.
If you would scan through it slowly, please.
Yes, I will.
Okay. All right, go ahead. All right. All right, he's talking about recidivism, so go ahead and scan past that slowly.
Oh,
Go back, please. All right. All right, scan slowly, please. All right, go ahead. All right, go ahead, please. Uh, see here. All right, the recommendation is 15 years, first 5 in custody. And he does say under 1710(7)(c), which is the recidivist statute. All right, and then, all right, you can keep scanning. All right. All right, you can scan further. All right, Mr. Dupree, have you read along that transcript?
Yes, sir. Yes, sir.
All right. So that was your guilty plea transcript back in 2008. There was a lot of discussion in there about recidivists. Do you recall that?
Yes, sir, it was. Yes, it was. It was requesting, if I didn't plead out, that was my attorney was telling me that if I didn't plead out, that I would be facing recidivism. But, by me pleading, that he non-prosperous citizen. And when I went down the road, my lawyer said it been non-prosperous and I was eligible for parole. That's all I know, sir, on that case.
And who explained that to you?
I paroled out like 7, 8 months later.
Okay, so Mr. Peters, are those all the exhibits?
Yes, Your Honor.
All right, so what are they, 1 and 2?
1 and 2. And I need to label the guilty plea hearing transcript as R2, and I'll do that.
Okay, so Mr. Dupree, the 2 exhibits, the indictment and guilty plea entry, and then the guilty plea transcript are both going to be admitted into evidence. You'll receive copies of this when you receive a copy of the record in the case.
You ready to say, sir?
All right, so.
You say I received copy?
Yes, sir, you'll receive copies
I
of all
was-
this. All right, Mr. Peters,
Okay, well.
is there anything else from your perspective?
No, Your Honor.
All
But
right,
what I'm
so-
saying,
So are you stating that the record is now complete?
Yes, Your Honor.
All right, now, Mr. Dupree, you can tell me whatever you want to tell me regarding that one ground about the recidivism issue.
Mr. William Hills.
All right, I'm not going to
before
hear
he
any
went out
more.
on-
Sir,
Mr.
I'm not going to hear any more about Mr. Henderson. You've told me plenty about that. The record is clear. He was not there entering the guilty plea for you. There was another attorney there. And the record clearly shows that.
Right, what I'm saying, she was just a backup attorney for him while he was out sick.
You've told me that, and you need to move on to your next
Okay.
claim.
Okay, I was kind of led to plea out, not knowing that my attorney counsel was also accountable for the alleged victim husband. At the same time, they was counsel for me, and I didn't know it, but during the hearing, he came out and spoke up and said, "Let me make one comment to the court. The victim in this case is the wife of one of my clients. I have discussed that with her, and she
Sir,
had no problem."
Mr. Dupree, you've
You said
alleged,
you want,
you have alleged before that that was a conflict of interest. The court's already
sir.
ruled on that. Court's already ruled on that. That claim's been denied. So move on to something else.
That claim been denied.
Yes, sir.
Okay, what about ineffective assistance?
You can still testify about that.
Okay, when I went down the road, when I was sentenced on this 2008 case, I was told that recidivism was non-pros on the fact that I wasn't proved that I had 3 of the same felony charges, but I had 4 felonies, but not the same charges of 3. So he said that by that being that, if I plead out, he's gonna put it in non-pros recidivism that I will be able to parole out. And I paroled out within 8, 9 months on the same case that they say recidivism.
All
So
right, and you had that,
I just need-
you're saying you had that discussion with your attorney?
I had that discussion with my attorney and also with my counsel in the state's penitentiary. My counsel that was over me during the time I was incarcerated had told me that I was getting ready to make parole and I need to take some classes. And I took some classes and I paroled out. So he was telling me that they was talking about trying to hit me up with recidivism, but that was my first time ever been tried with recidivism. So he's like, well, this is your first time, so they will give you a chance to prove yourself since about your first time. I never been sentenced on recidivism, and I didn't know anything about recidivism. But he told me, he said, don't worry about it. He said that they are trying to hit you with recidivism 3 times, felony or 4 times, but it's not the same felonies. It's different felonies. And I've been reading in the law, going to law, and saying you had to have the 3 of the same kind of felonies to be recidivism C for non-parole. But I don't have no same 3 felonies. And then, like, at the time that I was sentenced, I had 2 prior felonies, but I didn't have 3. But I had 2 prior and one present. The one in present was the one I just got locked up in 2008, but I had 2 more prior felony drug charges, but I never had the same 3 of the same. And that was spoken up, and I talked to Ms. Walker, and I told her about that situation, and she spoke up and told the judge and the DA that this was my first time ever being up on recidivism, and asked them to give me a chance and opportunity to be able to go down the road and parole out and learn from my mistakes.
All right.
And I went down, I paroled out, and I never had started on probation. When I went back to court on the 2013 case on the probation, I had never been started. I was still on parole down the road already because my parole was violated during the time I was in the county jail. So they sent me down the road on the same case before I even went to court. I was already down the road on parole violation. And I never reported on probation while I was out because I was on parole. My parole never stopped until after I went to court in 2013. I was still on parole. I didn't understand why they revoked my probation while I was already on parole during time. And I never started on probation yet.
Okay. All right, is there anything else, sir?
For that, you saying that the conflict of interest was denied up under what fact?
I'm sorry, what'd you say, sir?
You saying the conflict of interest was denied up under what fact?
I've already ruled on that there was no actual conflict, so I'm not gonna let you testify again about
I
that.
mean, he
Sir,
got it
sir.
on.
Sir, I've already ruled on that. There's no need to go into that.
Okay,
We did that at one of the previous hearings.
yes, sir. But what I'm saying, the only way I could get him to show that his wrong or line or whatever he did is by asking questions on record. And I could never get that across because I never get him to show up in court to get it on records.
Okay,
And
sir,
I
we've already talked about that. So if that's all you've got to say, I'm gonna let Mr. Peters ask you any questions he has. Mr. Peters, you
Well,
may.
really, it's not all I got to say, but this is my final statement that I would like to leave before I leave, sir. Your Honor.
So all I'm telling you is I'm not going to let you go through the same issues that we went through a couple of years ago. This hearing is only about the 2008 conviction, the recidivist issue, all the circumstances surrounding the entry of your plea in 2008. So I'm
Yes.
not going back through the 2013 issues.
Yes, sir, I understand that, but I was saying, I would like to leave my closing statement before I close.
What is your closing statement?
Your Honor, I request that you take this case under advisement and grant me habeas corpus relief.
All right, thank you. All right, Mr. Peters, what questions do you have?
No further questions, Your Honor.
Okay. All right, Mr. Dupree, that closes the record. You will receive a copy of the transcript along with the exhibits and everything that occurred today. And I will get you a ruling in the next few months. All right, have a good day.
All right, thank you, sir.
Yes, sir.
We didn't have. Two.
Okay, who's the guy? What's his name? We got an echo if you want. All right, Mr. Zell, are you there?
I am here.
All right, Mr. Zell, can you hear me?
Yes, Your Honor, I can.
All right, Mr. Baker? Mr. Baker, can you hear me? Can you hear me?
Yes, sir.
Okay. All right, this is case number 2019 HC 59. It's Raymond Baker versus Terrence Kilpatrick. Petitioner is present, represented by Mr. Zell. Mr. Peters is here for the respondent. Gentlemen, are both sides ready to proceed?
Yes, Your Honor, and if I can add, this is a continuation from June 23rd. We had appellate counsel that testified at that hearing. Mr. Garner, who is trial counsel, tried to testify, but he had issues with, I think he was on an iPad and he was unable to view some of the documents, so we had to continue it to where he could be in a better position to answer questions.
And I see he's available here today.
He is.
So, Mr. Zell, we can let you go forward with that, correct?
Yes, Your Honor.
Let me see if I can get Mr. Garner on my screen. He needs to turn his camera on, Mr. Zell. Somehow I've got him muted.
Mr. Garner, if you would enable your camera, there's a button down at the bottom that says Start Video.
Can
And
you see it now?
I can hear you, but you still need to enable your camera, sir. The button right next to the mute, unmute button, there's another button.
There we go.
There we go, sir. We got you now.
All right, good morning, sir. Mr. Zell, you want to go straight into that testimony?
Sure, Your Honor, we can do that. We can go ahead and swear Mr. Garner in and get to it.
All right, Mr. Garner, raise your right hand, please. Do you swear or affirm the evidence and testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, counsel, you may proceed.
Thank you. Would you state your name, please?
Michael Edward Garner.
And what is your occupation?
I'm a lawyer,
And how long have you been a lawyer?
49 years.
And are you licensed in Georgia during those 49 years?
Yes.
And as a lawyer, what is the primary focus of your practice? Criminal or civil?
We do criminal defense.
Is it 100% criminal?
Yes.
And did you at some point represent Mr. Baker?
Represented him at the trial.
Did you do you recall at what point you began to represent Mr. Baker? Was it like after arrest, or how long before the trial, I should say?
I don't recall. I knew I represented him sometime before the trial.
Okay. Do you recall whether or not you had sufficient time to review the case, like the discovery, and prepare for it?
Yes, I did.
Okay. And you developed any kind of trial defense for it?
Yes, we had a defense.
Okay. Do you recall what that defense was?
Our defense was that this was an ongoing criminal enterprise where Casanova Houston, his brother, and his mother had been conducting home invasions, I think exclusively by Mexican immigrants. They would go in and do a home invasion. They had done that for some time, done a number of them. Near the end of this enterprise, they had asked Mr. Baker to help them with an incident. And he went and was out in the car, going to drive the car. And that's what he did.
Okay.
He
Now,
had said that, Casanova Houston made a deal with the DA to testify. And the things that Casanova Houston's brother had done, which was go in these residences with a gun, they said it was Raymond Baker that did it when he didn't do it. So the fact that he didn't participate in some of these incidences for which he was convicted, and the fact that his participation was such that he shouldn't have been convicted under the felony murder rule, that was our defense.
okay. So in that description, I think you kind of touched on the two issues we have raised. So I'll start with the first one. You mentioned that, or you testified that this was an ongoing series of events of home invasions of Mexican immigrants.
That's correct.
Were there do you recall the indictment? Was there more than one incident indicted, or what, more than one home invasion indicted in the against these defendants or some of the defendants?
I can't really tell you because this indictment was like 60, 70, 80 counts. It included all kind of incidences. There were a number of people involved. It was a very extensive indictment. And of course, Mr. Baker not having participated in much of this, he was not mentioned in a substantial part of the indictment. But all of the incidents that it covered and the people that it covered, I couldn't tell you without seeing the indictment. It's like pages and pages and pages,
Okay.
counts, counts, and counts.
Now you just testified that he wasn't indicted in every count in the indictment. Is that what you recall?
I don't think he was even mentioned in the first half. I mean, there's like 30 or 40 counts where it goes through all this stuff that happened, but they never mentioned him until toward the end.
The fact that he wasn't indicted in roughly half the indictment, does that refresh your memory as to whether or not there were other incidents alleged in the indictment?
Oh yeah, there were a lot of incidents alleged in the indictment.
Okay. And when I say that, I mean other dates or other times than the one for which Mr. Baker was convicted?
Yes.
Okay.
Multiple incidents.
Okay. All right. So now, there was this, during the trial or before the trial, there was a motion by the state to introduce a prior similar transaction or guilty plea of Mr. Baker of an armed robbery. Do you recall that?
Yes.
Okay. And do you recall whether you objected or did not object?
Well, I think I let it in without objection. Sorry to say.
Do you recall why you did not object?
Well, I didn't recall until I read the transcript, but apparently I didn't challenge it because it was not similar. And I knew it wasn't similar because I represented Mr. Baker on the similar transaction.
Do you normally, as a defense attorney, want similar transaction evidence to be introduced in trials against your defendant clients?
I've never had an incident where I wanted similar crimes to come in front of a jury.
Did you want the jury to know Mr. Mr. Baker was a convicted felon?
No,
Did you want the jury to know that Mr. Baker had actually been convicted of armed robbery, which was the basis of the indictment for which they were impaneled to try him?
no, that would have been too prejudicial.
Okay. At some point during the trial, there was talk of, I guess, strategy during a hearing on on what evidence could be admitted in the similar transaction, and whether or not you were trying to contest the facts of the similar transaction. Do you recall that?
I'm not sure I understand what you're asking.
Do you, at some point during the trial, the state presented witnesses to support the similar transaction evidence?
Oh, yeah, I remember them doing that, and my recollection is that because he had pled guilty, it didn't occur to me to contest it on the basis that it was not similar. At that time, I believe you could contest it on the basis that the similar transaction was not similar enough to the charges that he was on trial for to be admissible. I think I just missed that. I didn't do it.
Okay. So, and at some point during the similar transaction testimony, do you recall whether or not you wanted to introduce evidence through one of the state's witnesses regarding the facts of the similar transaction?
I don't recall that specifically, but I feel like that's what should have been done. But like I say, I just missed that thing. I didn't do anything about it. But the similar transaction was a robbery at a grocery store. And what he was on trial for was these home invasions.
Okay. Now, I want to, I don't recall, Mr. Peters, I don't recall, or Your Honor, if we introduced the transcripts of the last hearing, but I'm going to go ahead and, I assume that one of us is going to tender them at some point during this hearing. So I would like to screen share one page of this transcript.
That's fine. Yeah, that's fine.
Okay. This is volume 4 of the trial transcript, page 26. What is the trial transcript did not go in order like page 1 to the very end. Each transcript started over, which is why volume 4, there's a page 26. So let me screen share this, and Mr. Garner, see if you can, you're speaking, and see if you can recall this portion right here. Let me get to that. Screen share here. Well, I did this on Monday at a different hearing, so I know it's on here somewhere. I just do not see the screen share here right now. I don't know why. Share. Okay.
There it is.
Okay. So this is during the similar transaction hearing. It's on actually page 20, I think it's 26. And there you are, Mr. Garner. If you could read that down to where, I guess down to where pretty much the whole page, and see if that refreshes your memory as just part of the similar transaction hearing.
Okay.
Okay. So in that you can see, I'm going to stop share. Well, I'll leave it up there for just the time being, just in case. But so in that there is reference to strategy of wanting, owning up to the jury that he did this one. He's an honest guy. So if we say he didn't do this one, he didn't do this one. So do you recall that was referenced as a strategy in the similar transaction?
Yes.
Is that still something, did you purposely want the similar transaction to come in just to present that strategy? Or
No.
was that strategy
No,
because, go ahead, I'm sorry. You need to explain.
That's after after it was coming in, we wanted to try to, you know, make lemonade out of lemons.
Okay. All right. So it wasn't a situation where you wanted that in just to show that he was an honest guy in this trial.
No, we did not want it in. But apparently, it's like I said, I forgot to challenge it because it wasn't similar. And that must be why I didn't, because I wanted it to come in to show that he admitted to it, thinking that would help. But apparently that was, it just missed the fact that it wasn't similar. I should have done it and I didn't do it.
And so what he was on trial for was a home invasion of some immigrants, and the similar transaction, was it the same thing, or what were the basic facts of the of the prior case?
The similar transaction.
Yes.
He had somebody at the Lewis Jones supermarket tell him when they would take the money to the bank, and he intercepted the employee from the Lewis Jones supermarket to take the bank bag, which he did. And I believe that the employee gave him the bank bag, and that's how he took the money from Lewis Jones, which is totally different from what the Houston gang was doing, which was targeting Mexican immigrants who wouldn't go to the police and going in with 4 or 5 people and robbing them at gunpoint in their home.
Okay.
Just 2 different things. I didn't think to object on that basis.
All right. So now I'm going to go into the second issue, and that is you've also testified about him, and that is Casanova Houston.
Yes.
Casanova is an unusual spelling. It's spelled C-A-S-S, I believe, I-N-O-V-A, and then Houston is the normal way. What was Mr. Houston's role in this case?
Well, he and his brother were the ones who carried out these series. It was their mother's idea who put them up to it. And that's what they did. It was like a family criminal enterprise.
Did he enter a plea deal to testify against Mr. Baker?
Yes, he did.
Do you recall if any of the victims were able to identify Mr. Baker at trial?
I think that they claimed to identify something about a hat or something like that.
Okay.
I can't recall the specifics.
Do you recall if Mr. Houston was would you consider him a material witness, a key witness in the case against Mr. Baker?
Yes, he was the witness.
Okay. And do you recall what his plea deal was, or what the terms of his plea deal was before he testified?
Well, he's the one, him and his brother is actually the one that killed everybody. And they didn't plead guilty to murder. I think they got voluntary manslaughter. And they got, I think, a sentence on armed robbery. Might have been, I'm not sure, but I think it was 20 years on armed robbery.
Okay.
But the plea deal was not just for him. I interviewed him before the trial and he talked to me. I went to the jail and interviewed him. And he made a deal that covered him and his brother and his mother. They all got off on it in return for his testimony.
Okay. Now, at some point, you recall cross-examining Mr. Houston on his plea deal?
Yeah, I cross-examined him.
Okay. Now, was Mr. Now you mentioned this long, big indictment. Do you recall whether or not Mr. Houston was his prevalence during I believe it was 66 counts of the indictment, how many counts he was charged in?
The Houstons should have been charging just about all of them.
Okay. Now, did you ask Mr. Houston if he was avoiding a murder charge? You recall if you did that?
I think I asked him what he was going to plead guilty to under his agreement. I'm not sure.
Okay, let me go back to this. Page 230, volume 3, page 230. This is recross examination. Can you see that on the screen? Can everybody see that on the screen?
I can.
Okay. And line 5 through 11, or line 5 through, I guess, 14, or line 5 through actually 19, I'll take it back.
Yes, that's what I recall.
So do you asked him if he was avoiding pleading guilty to murder and a life sentence?
Yes. But it was for him and his mother and his brother. They all got that.
Okay. Now, how many murders were there?
2.
So you referenced 1 murder, not 2. Is that correct?
There was only 1 murder where it was alleged that the defendant here was present, but I think there were 2 separate murders,
Okay.
2 separate incidents.
Okay. And did you consider at any point pulling out the indictment and going through counts 1 through 66 with Mr. Houston to go over the possible sentence of each and every count with Mr. Houston?
I wanted to go over the fact that there were all these counts in the indictment where Mr. Houston was present and the defendant was not. And to point out what Mr. Houston and his brother and his mother were facing.
But you did not do that?
I didn't do that.
So in other words, like you did counts, let's see. And I'll just as example, count 1, Mr. Houston, you're charged with armed robbery. You're facing the mandatory minimum is 10 years without parole, up to 20 without parole, and then up to a life sentence. You could have gotten did you consider doing that for each and every charge? All the armed robberies, all the murders, all the aggravated assaults?
Well, I didn't usually do it that way. What I did is, what I would do when you question somebody like that is to go through the indictment and tell them, you got so many counts here, and you got so many charges of this, yeah, and you got so many charges of that. And when you add all this up, if you were convicted, this is what you would be looking at. you would be looking at never getting out of prison. Isn't that true? And isn't that why you're testifying like you're testifying? Because you were told by the DA that this is what's going to happen. Because you got a life sentence here and a life sentence there, and you got like 14, 15 life sentences. You got all these other charges that add up to hundreds of years. But you point out that especially on these armed robberies, which is a lot of them, there's no parole on those.
Do you recall why you didn't do that in this case?
Well, I didn't do it that, and I didn't do things about me talking to him in the jail and about his mother getting off, because every time I would try to question him, and you see this is a redirect that you talk, but all during the trial, especially him and another detective, the judge kept interrupting me and the DA kept interrupting me. And it got so frustrating. We kind of had a scene where I just blew up and asked for a mistrial and just demanded that the DA and the judge quit interrupting me and let me cross-examine these witnesses. Because, and by the time you get to here where we are, I just sort of gave up because I know I'm not going to be able to do it. And if you look at the transcript here, you'll see I'm just continually interrupted, just continually. And it was a strategy by the DA, and the judge let him do it. And the judge kept interjecting questions too. I don't know why.
In fact,
But,
did that
got
occur
to be a
during,
pretty nasty situation.
did that occur during Mr. Houston's testimony?
I don't know if it was his,
Okay.
but
Did-
it had happened before that, and it had happened on like 50 times.
And you testified you kind of blew up. Do you recall the judge actually took a break in the trial and told you to calm down?
Yes,
Okay. Okay. And
never been treated that way before.
so normally you would, in this kind of situation, it would be your practice to, you could get a, life for murder, you could get life for this murder, life for this armed robbery, and they could all run consecutive. And
Yes, and I would have gone in.
my video turned off by mistake. And based on this, you would die in prison, so to speak. That would be the end of it. You'd never get out.
Yes, but you have to go further than that. What you do is, see, the way it always worked in this county is the DA would get the cooperating co-defendant to plead guilty, and they would have a discussion about the sentence, but there wouldn't be a specific sentence promised. And that's the way, and what you do is you go through all that you're talking about what he could face. And then you get to the point of the deal where he and his lawyer are talking to the DA, and you're getting down to which sentence he's actually going to get. And what they always do is they talk about a sentence, but they don't promise a sentence. And you go into that too about what have you been promised that you're going to get in the way of a sentence.
Do you recall in this case whether or not Mr. Houston actually received a substantially less sentence than they talked about when he testified at trial?
I think he did, but I think that they were talking about 30 years, but I can't remember. I think he got 20 years, but it was on armed robbery without parole.
Okay.
But nothing was consecutive.
Okay. All right. That's all the questions I have.
All right, Mr. Peters, do you have any questions?
Just a few, Your Honor.
Yes, sir.
At the time you represented petitioner, approximately how many felony trials had you handled at that time?
I'd say about 200 or 300.
Were you appointed or retained?
I was retained.
What did you do to prepare and investigate the case?
Well, we had a pretty good arrangement with the DA about getting the discovery. They were pretty good about complying with the discovery, and we'd get the discovery. And I got the statement by everybody really, and that's why I went to interview Casanova Houston at the jail before the trial to try to see if he was gonna, tell the truth about my client, because if he would have, we were in good shape. And we sort of got wang bang there because I thought we had a chance to win a trial. I had no idea that they were going to just throw everything off on this defendant, which they did. I wasn't expecting that.
Okay. And did you discuss with petitioner the weight of the state's evidence in the discovery?
Well, I kind of misinformed him about that based on my assumption that Casanova Houston was going to tell the truth about what happened. Casanova told me about the deal he made, and he was going to testify, and that he had an agreement that he and his mother and his brother were not going to get any murder convictions, and that they were going to come out pretty good. He was going to get no more than 30 years. But he didn't tell me I'm going to put everything my brother did off on Raymond Baker. Didn't tell me that. So rather than pursue it, if I would have known that this was going to happen, we would have probably been trying to make a deal ourselves.
What was your theory of the case?
My theory of the case was that this defendant didn't do enough in the way of acts that he committed for his participation to amount to felony murder under the felony murder rule. And they would have gotten him for armed robbery, maybe. But, he came in at the tail end of this. All he was supposed to do was drive a car. That was the agreement he had with them. And there was not a lot of discussion about what they were going to do. But the fact that he would have done anything like go in the house or do anything that could be construed as qualifying for felony murder, we had a good argument there.
No further questions.
All right, anything else, Mr. Zell? All right, Mr. Zell, you're muted.
No, Your Honor.
Okay. All right. Mr. Peters, do you have any documents to present?
Yes, Your Honor.
And Mr. Garner, you're excused. Thank you very much, sir.
Thank you, Your Honor.
Have a good day.
Okay, I'll go ahead and share my screen and go through the exhibits we have. Can you all see that?
We can.
Okay. R1 is the clerk's record prepared for appeal. Let me know how long you'd like me to scroll.
Mr. Peter, and Your Honor, I will, unless you hear from me, I'm going to have no objection. So you
Okay.
can, so you don't have to scroll. You can just tell us what it is. And, you know, we've done these significantly enough that we know what the records are, and I've seen them already.
R2 is the indictment. R3 is a pretrial hearing transcript. R4 is trial transcript volume 1. R5 is the trial transcript volume 2. R6 is the trial transcript volume 3. R7 is trial transcript volume 4. R8 is trial transcript volume 5. R9 is the motion for new trial hearing transcript. Excuse me, R9. R10 is the brief of the appellant. R11 is the DA's brief. And R12 is the brief of the AG. And those are all the exhibits we have.
All right, any objection, Mr. Zell?
No, Your Honor.
All right, they're all admitted without objection. And Mr. Zell, I neglected to ask you earlier, do you wish to present any testimony from the petitioner?
No, Your Honor, I don't need any testimony from the petitioner.
All right, and we've had a previous hearing where you offered the testimony of appellate counsel, now trial counsel. Do both sides agree the record is complete now?
Yes. Yes.
Yes, Your Honor.
All right, gentlemen, thank you. That would conclude the evidentiary hearing.
All right. Thank you, Your Honor.
Yes, sir. All right, Mr. Peters, I'm going to take just a few minutes, maybe 3 or 4 minutes, and then we'll get on the record. Which case do we have next?
Scott Davis.
Okay. All right, thank you.
Thank you.
Yeah. Yeah. There's somebody that doesn't have much to do. All right, good morning. Mr. Davis, can you hear me?
Yes, sir.
Okay.
Good morning.
Good morning. All right, the case is 2020 HC 33. It's Scott Anthony Davis versus Brian Adams. I'm showing a Mr. Is it Scott Key as the attorney?
Yes, sir.
He's not on with us. Oh, he's here?
I believe he's one of the attendees, Your Honor.
All right, he's not up on the screen. Here we go. Okay.
Hello, Your
Yes,
Honor,
sir.
can you hear me okay now?
I can, and I've just called the case. And counsel, are you ready to proceed?
I believe I am. I have a Brad Moody under subpoena, and I see him showing up as an attendee as well.
Okay.
I'm on, but for some reason it having issues trying to get my video. There we go. Now I can start video. Morning, everyone.
All right, good morning. And Mr. Peters, you're here for the state?
Yes, Your Honor.
All right. And I don't have the file in front of me, so can you give me a general synopsis of the case?
Petitioner is currently challenging his 2013 Spalding County convictions arising from a jury trial for aggravated child molestation, and statutory rape. Those convictions were affirmed on direct appeal in Davis v. State, number A19A1077. That's a Georgia Court of Appeals case from 2019, and it's unpublished. In the original petition, petitioner raised 2 grounds. In the amended petition, he raised 7. And if you'd like, I can go through those grounds.
If you would, please, just briefly.
Yes, Your Honor. Ground 1 of the original petition, petitioner alleges that counsel was ineffective for failing to request the pediatric and medical records for the victim and did not request an in-camera review of those records.
And Your Honor, we will not be going forward on that
So
claim.
You're withdrawing that ground?
I am.
And just so we're clear, petitioner had the same attorney at trial and on appeal, and that attorney's name is Lee Sexton, and he has since passed away. Okay, continuing with the grounds of the original petition, ground 2 of the original.
Your Honor, we'll be abandoning ground 2 as well. We're only going to go forward on the grounds in the amended petition.
You said those were 7 grounds
That's
in the
correct.
amended petition?
Yes, Your Honor.
All right, and what are those grounds?
Okay. So ground 1 of the amended petition, ground 3 overall. Petitioner alleges that counsel is ineffective for failing to raise the trial court erred in failing to grant a continuance for trial, as counsel stated on the record that he was not ready or prepared to move forward, nor had he had an opportunity to consult with petitioner prior to trial. Ground 2 of the amended petition, ground 4 overall, petitioner alleges that counsel is ineffective for failing to raise that the trial court erred in overruling the relevancy objection during voir dire when the state asked, quote, "Does anybody here believe that sexual crimes or sexual misconduct, however you want to talk about it, does anybody believe that when they do occur, that they are always reported? What are some reasons why a person may not report that? Remember, we heard some things like embarrassment. What are some other things or reasons why you think someone may not come to court and say that?" And when rephrased to the judge, the state was asking, what were some reasons why a person might not come right out and tell somebody about a sexual crime? So that is ground 4 overall.
Okay.
5 overall, ground 3 of the amendment. Petitioner alleges that counsel is ineffective for failing to raise the trial court's error in allowing a witness, Mr. Steve Hayden, to testify over objection as to whether petitioner sounded desperate, quote, in voicemails. And to the extent the trial counsel did not make the correct legal objection, trial counsel is ineffective for not making a relevancy and speculation objection, and in turn, failed to properly preserve the record for appeal. Ground 6 overall, petitioner alleges that counsel is ineffective for failing to raise that the trial court erred in overruling a hearsay objection and confrontation clause objection regarding statements from Katie/Kathy Hayden, who was the outcry witness's mother, that was on the witness list but never testified. Ground 7 overall, petitioner alleges that counsel is ineffective for failing to raise that the trial court erred in overruling a relevance objection as to how, quote, the entire ordeal, end quote, affected the alleged victim, Mrs. Glass. Ground 8 overall, petitioner alleges that counsel is ineffective for failing to investigate and prepare all viable issues on appeal. Counsel originally enumerated 8 total issues in the amended motion for new trial, but abandoned these issues for the appeal at the motion for new trial hearing. And lastly, ground 9 overall, petitioner alleges that counsel is ineffective for failing to object to the state's improper closing argument when the state argued to the jury that they, quote, had a duty to think about Geraldine in keeping the law and deciding whether petitioner was guilty. And those are the grounds as we understand it.
All right, then, counsel, you may proceed with your evidence.
Thank you, Your Honor. And just by way of just informing the court a little bit, Brad Moody worked with Mr. Sexton in his practice, and I believe Mr. Moody he worked on at least the appeal and was part of the trial at some point, at some level. And so he is kind of the only witness that I have that I can call who would have some knowledge of the grounds. Otherwise, Your Honor, to the extent that Mr. Moody will not be able to speak on some of these issues, what I would request is obviously once the exhibits are tendered would be the ability to argue ineffective assistance from the record as well, and to be able to submit that later in the form of a brief and proposed order.
And that's fine with the court.
Right. And I would call Brad Moody.
All right, sir, raise your right hand. Do you swear or affirm the evidence and testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
State your name, please, for the judge.
My name is Bradley D. Moody.
And did you have any role in the pretrial, trial, and appellate phase of State of Georgia versus Scott Anthony Davis?
Yes, I did.
And we'll kind of start with pretrial. What involvement did you have prior to the trial of the Scott Davis case?
This case, I believe, started back in like 2011. I don't remember the exact date that we were retained, but I know that we were retained fairly early on. Mr. Davis had the facts, the allegations made in this case span several different counties. It wasn't just Spalding County, so there was a lot to go through in trying to work all of the allegations, because we had Newton County, we had Butts County, I think we even had Houston County as well as Spalding County, and maybe Lamar. I can't remember. I know that there was a wide net that had been cast stating that, you know, the allegations had happened here or happened at some other place. So it was a very involved case as far as trying to sort everything out and developing the defense. And Lee and I met with Scott, met with the family, met with, you know, every different person we could, and trying to get witnesses together, and then trying to negotiate with each and every jurisdiction prior to going to trial.
And let me back up just a little bit. When you said Lee and I, you're referring to Lee Sexton?
Yes, sir. And I mean, I know a lot of people know him pretty well, but Mr. Sexton at this time, I had been working with him, I think at least 3 or 4 years. And on big cases, especially involved ones, he liked to have a second set of eyes and ears.
Okay. And you obviously are you're a member of the State Bar of Georgia, and you functioned as a lawyer on the Scott Anthony Davis case.
Oh, yes, sir.
Okay. And I know that your name is not listed in the trial transcripts as being counsel in the case, but
yes,
were you present during the trial?
Yes. Not for the entirety of it, but I was present for, I know closings, I know voir dire, and I know during while we were awaiting a verdict. I believe that because there was some out-of-state witnesses, and there was times that I had left to go try to make sure we had witness people had the witnesses in line.
So you were in and out of the proceedings because you were lining up and coordinating various witnesses.
During the evidence phase, yes. I
All
didn't
right.
leave during voir dire or in closings.
Okay. And then after Mr. Davis was convicted and sentenced, what was your role between sentencing and when this case ultimately was resolved in the Georgia Court of Appeals?
Specifically with this jurisdiction, or just in relation to Mr. Davis?
In relation to the trial that took place in Spalding County and the sentence in Spalding County and the appeal of that conviction.
After I know I worked with the family in getting the transcript procured, because we had some issues trying to get the court to give him the transcript since he was now in prison as opposed to being able to afford it. But other than that, we obtained the transcript. I read through it all. Lee and I met probably 3 separate occasions trying to narrow down what we could allege, what we thought would be good pieces for the motion for new trial. I met with Scott's wife. I know I met with her one time prior to the motion for new trial, but I talked to her several other times.
And did you ultimately draft the brief? I know you didn't sign it, but did you ultimately draft the brief of appellant in this case?
Drafted the motion for the amended motion for new trial and the brief of the appellant.
Okay. Were you involved in the selection of issues to be raised at the motion for new trial?
I was.
And were you involved in the selection of issues to be raised in the brief of appellant?
I was involved to the extent that Lee and I met, and I said, look, I think this is probably the better of the issues to go forward on. And he ultimately made the decision on what to put into the brief, because the brief I had originally drafted was a little bit longer and had more issues, but Lee was the one who ultimately said, no, let's cut it down to this and this and send it in.
Okay. And why is it that you didn't sign off on the briefs in the case, and why you don't appear? I mean, you probably don't know why you don't appear in the trial transcript as attorney of record, but in the brief of appellant, why does your name not appear?
That I don't know. I didn't format it. I did the grunt work on it and then sent it to our paralegal who put it together and sent it off. After that, I don't know. I didn't tell her not to put me on there.
Would you have considered the level of work that you did on the case to be sufficient to have considered yourself one of Mr. Davis's lawyers?
I would think so. Heck, I would think Scott would even think so. I mean, I know I dealt with him several times, and especially in other jurisdictions other than Justin Spalding. I believe that he would have considered me that. I believe I signed off on a plea for him in one of them.
Objection, Your Honor. That's speculation of what a deceased individual state of mind or belief would be.
Or the petitioner.
I mean, you're speculating as to what his belief would be of your role. So I would object.
Also,
Counsel, you want to respond to that objection?
Well, my question to him was whether or not he considered himself to be counsel in the case for Mr. Davis. And I believe what he was commenting on was not really speculating as to Mr. Sexton's state of mind or his client's state of mind. But I think what he really, the ultimate content of what he was saying is he's speaking to his level of involvement in the case and whether or not it was sufficient to be considered for him to be considered co-counsel. I don't think he was actually speculating as to what somebody else thought.
Yeah, I don't know how relevant it all is, but I'll overrule the objection.
Okay. All right.
I mean,
So let me
did
ask
some
you
work.
this.
We've established that.
Yes.
Yes, sir. Yes,
Right.
sir. And I think I'm about done with that.
Sure.
With that chapter anyway. So Mr. Moody, have you had the opportunity to review my amended petition for writ of habeas corpus?
I have.
All right. I'm just going to kind of go through them one by one. Do you recall that on the eve of the trial of this case, and I don't mean literally the eve, but in a short period of time before this trial began, that Mr. Davis was charged and ultimately incarcerated in another county?
Yes.
And were there issues that you and Mr. Sexton experienced in terms of having access to Mr. Davis as a result of him being incarcerated on another
Absolutely.
warrant in another county?
Absolutely.
All right. Could you speak a little bit to that topic?
I can't remember exactly what county it was because I believe going through this, I think we were in at least 5 jurisdictions. I'm not sure exactly what county it was, but I believe it was 2 weeks leading up to the trial. It might have been a month, but prior to the trial, he got taken into custody somewhere else, and his family had told us he got taken into custody, but trying to actually link up and get to speak with him, we weren't able to accomplish that. There had been, we met, I know I personally met with the assistant district attorney on the case at the time, it was Jordan Van Meter, and told him, hey, Mr. Davis got locked up over here. We're going to need a production order if we intend to do anything with this case. And I believe that one was done. If not, there was at least a gentleman's agreement that had him brought to Spalding just before the trial.
All right. And
I know he wasn't in Spalding the week before the trial, so we couldn't meet with him.
And do you recall at the beginning of the trial of the case in Spalding that Mr. Sexton had raised the issue of not being able to confer with his client as a result of his being incarcerated in another county, and how that ultimately made him not prepared for trial, and that he ultimately requested a continuance on that basis?
Oh, absolutely. Because prior to starting the trial on Monday, Lee and I met that Saturday, and he was telling us that, well, I don't think Edward's going to make us go out because I can't talk to my client. We haven't been able to, because I know Scott hadn't been brought to Griffin the week before the trial, and I'd like to say it was kind of over the weekend that he was even brought over. So I know we couldn't meet with him and prep him prior to any of that.
And a moment ago, you used the word Edwards. You were speaking of Judge Christopher Edwards, who
Yes.
presided over the trial of the case in Spalding. Is that right?
Yes, sir.
And did you believe that a continuance was necessary based upon the inability to confer with Mr. Davis prior to the beginning of this trial?
Absolutely. One of the pillars of our defense was going to be that Scott was going to need to testify. We in a case like this, it's oftentimes my belief that, and my strategy, that a jury's going to need to hear the accused get up there and say, I didn't do this. Because a lot of times, we can tell a jury until we're blue in the face that you can't consider silence against him, but these are normal people, and don't always follow the legal standard. So I knew that going into this, and we had talked to Scott early on in the case, that he was going to need to testify.
And did you ultimately ultimately the continuance was denied, correct?
Yes.
The motion for, and on appeal, did you raise the court's failure to grant that request for a continuance?
I personally did not.
All right. Do you recall any reason why you did not?
No particular reason. Honestly, I didn't. I'm not one that does a ton of appellate practice, but I know that when I was looking at it, it's like we had announced that we weren't ready, but then going through the trial, it was a week-long trial, and we were able to keep up with it. I didn't know that it would be one that would be strong enough to go into an appeal with, on the failure to give us a couple more days or even a week. So I didn't personally think it was a good one.
And going back to the appeal, do you recall ultimately that the court had to send that the Court of Appeals sent a notice out that the brief had not been timely filed, and the notice threatening sanctions if the brief were not filed by a date certain?
I don't. I've looked through our file and I see that, but I don't personally remember that happening at the time. But I remember I see it in the file. But I don't know if it was the brief wasn't done before then or the brief was done, it just hadn't been submitted. I couldn't tell you.
Okay. What was there at some point a time pressure or a time crunch based upon the brief having been filed or not having been filed when it was due?
I don't
In
specifically
terms of were you the initial person who drafted the brief of appellant in this case?
Yes, sir.
Okay. And you're having looked through the file and looked through your notes, you're familiar with there being an issue with the timeliness of the filing of the brief of appellant.
Yes, sir.
Okay. Moving on to the next, and I have the transcript in front of me, Brad, anytime that you want to look at it, but I'm moving counsel to my fourth ground. Do you recall that Mr. Van Meter, or having reviewed the transcript, that Mr. Van Meter asked the jurors in voir dire questions that were potentially prejudging the facts of the case?
Yes.
And I'm just going to read from transcript 64 through 65.
Counsel,
Does anybody?
I'm assuming he's the prosecutor, the assistant DA?
Yes.
Okay, all right.
So this is I'm reading now the assistant DA talking to the jury.
Okay.
Does anybody here believe that sexual crimes or sexual misconduct, however you want to talk about it, does anybody believe that when they do occur that they are always reported? What are some reasons why a person may not report this? Remember, we heard things like embarrassment. What are some other things or reasons why you think someone may not just come out and say that? What are some reasons why a person may not come right out and tell somebody about a sexual crime or assault that they had been through? Do you recall that Mr. Sexton actually objected to this line of voir dire questions?
He did.
And do you, in hearing this and well, really, and when you read through the transcript, did you think that Mr. Sexton had made a good objection?
After reading the transcript and then reading your specific grounds, I think that he could have objected better. I think there could have been another citation in his objection, as opposed to just relevancy. But honestly, I think Lee was just trying to get an objection in there and make him stop.
Okay. Do you recall ultimately if Mr. Sexton's objection was overruled?
It was.
Did you at the time that you reviewed this transcript believe that the questions being asked of the jurors were proper questions to ask?
I mean, at the time of the appeal, at the time of the trial, I didn't think that it was a good line of questioning, but that wasn't our focus when it came. Well, that wasn't Mr. Sexton's focus on stuff like that.
Okay. Did you believe at the time that you reviewed this line of questioning that these questions were, and I understand it was a relevancy objection, but at the time that you reviewed this line of questions, did you believe that that the state, Mr. Van Meter here, was asking the jurors to prejudge the facts of the case during voir dire?
Objection, relevancy. His belief is irrelevant. He wasn't doing the voir dire, Mr. Sexton was.
Well, I think it is, because he ultimately crafted and had a role in the selection of issues, and I'm trying to figure out if his not raising it on appeal was because he didn't discern an issue or whether or not there was some strategy involved.
Okay, I'll allow it. Go ahead.
And you're asking, did I think that Jordan was asking the jury to prejudge the?
Yes. Yes.
And looking at the question, yeah, I mean that's pretty plain on its face. So I think yes.
Did you think so at the time that you were reviewing the transcript and drafting the brief of appellant?
Give me just a second, because I have my copy of the transcript that I used when doing this.
Do you want me to, with the court's permission, to put it up on the screen for you to see?
Do you have my specific one that our office provided to you, or is yours a fresh one?
Mine is provided from your office.
All right, so it has all the highlights and such on it.
I think so.
Okay, yeah, if you can put it up, because that would. I know I highlighted a whole bunch of stuff that we didn't ultimately send in the appeal.
And Your Honor, I know that this exhibit is not up yet. I think one of us will ultimately have this. It'll ultimately be a part of the record. And may I display it to Mr. Moody to refresh his recollection?
You can.
All right. Are you able to see that, Mr. Moody?
Yes.
All right.
Oh, yes. I'm see it now where I highlighted pretty much. And that, as soon as I read that, I believed it to be problematic. And I know that when everything that I've highlighted, we at least discussed prior to putting together either one of the documents for the motion for new trial or the appeal. I don't know if this was. I can't remember if this was a part that I left on the cutting room floor or that Lee left on the cutting room floor.
Okay. And now at the time, I believe that the objection that had been made was relevance, and you
Yes.
can see that at 64 lines 18 through 20. Did it occur to either of you? I mean, you can't speak to Mr. Sexton, but did it occur to you, or was it an issue of discussion whether or not these questions were asking the jury to prejudge the case and the facts of the case?
And when I'm reading it, looking at the text of the question, I thought that it was asking them to prejudge. But obviously we didn't. That wasn't the objection made. So I don't know if I can't remember specifically if that's the reason why we left that out or what it was. But also knowing that we were both trial counsel and appellate counsel, we were slightly restricted on whether or not we could say that we were bad in and of ourselves.
Okay. And you said earlier that you were present during voir dire. Is that
Yeah,
correct?
I was.
And you believed yourself to be functioning as Mr. Davis's counsel as well as Mr. Sexton during voir dire.
Yes, sir.
Did it occur to you during voir dire that these questions that Mr. Van Mater were asking were asking the jury to prejudge the facts of the case?
I don't remember specifically this question. If I remember correct, I think Lee objected to 2 or 3 different questions during voir dire, and a lot of that time, heck, I would sit next to Lee during any time that I was there and kind of be a second set of ears and tap him if I thought it was time for him to jump up.
Okay. And do you recall whether you tapped him to jump up at this point?
I don't specifically.
Okay. All right. Counsel, and for the court, I'll be moving on to ground 5 now. If you recall, who was Steve Hayden in this case?
I don't know if he was kin or just a friend of the girl's folks. He was involved on the essentially the opposing side. He wasn't an agent of the state or anything, but he was some relation to the alleged victim's family or a friend of the family.
Okay. And do you recall that there was an issue about a set of voicemails that Mr. Davis left with Mr. Hayden related to the case?
Yes.
Okay. Do you recall there being an objection during the course of the trial where Mr. Hayden testified that Mr. Davis, your client, quote, sounded desperate in his voicemails.
Yes.
Okay. And do you recall that Mr. Sexton actually objected to that testimony?
Yes.
Do you recall what that objection was?
Um, he probably objected to relevancy. I don't see it specifically in front of me or know offhand, but if I had to imagine, Lee probably would have objected on relevancy grounds.
If I showed it to you, would it help refresh your recollection?
Yes, sir.
If the court may I display this to
Yes,
the
sir.
witness, Your Honor?
Go ahead.
Counsel, let me go into page 182.
Okay.
I think I'm in the wrong volume. Hang on just a second. Okay, Mr. Moody or Brad, do you see the highlighted portion here in
Yes.
page 180,
Yes.
183 of the transcript? Now, if we see highlights in this transcript, are these your highlights?
They are.
Right. And so you see Mr. Sexton says, well, Judge, that calls for a conclusion on the part of the witness. And
Yes.
then the court specifically says overruled on the grounds stated.
Yes. And looking at that one, that's one that I remember discussing with Lee, and I think that the reason it was kind of left off was that we weren't sure if in looking at it, in Lee's kind of speaking objection on calls for a conclusion on the part of the witness, it's hard to tell if he was specifically stating, this is an expert opinion, or if this was just a bad opinion, or if Judge Edwards just took it as a completely different point of the objection. I read it to be that, Lee was objecting that the witness was lodging an opinion as opposed to stating a fact that he could observe. So
When the judge says overruled on the grounds stated here, as a trial attorney, did you take that as potentially a hint from the trial judge?
I did. I mean, in reading the
All right.
transcript, I did.
Do you believe, just having done this, that there might have been a different grounds upon which he would have sustained the objection?
Likely. I mean, I think if
Objection, speculation.
Well, I think it
I
goes
have to agree with him there.
Okay. Do you think also that there would have been a legal grounds for objection on relevancy?
No, there definitely would be, but I think better was based on essentially trying to opine on Mr. Davis's perspective when he was leaving the voicemail.
Okay, and so when we see the highlights here on the screen, those are your highlights. And so when you highlighted things in this transcript, were you
Yes.
highlighting things because you thought these were things that were potential appellate issues, or they were of interest to you as you reviewed the transcript?
Yes. Anything I highlighted was something that I wanted to discuss with Lee before we drafted anything or as we drafted it.
Okay, and ultimately, I think you used the word cutting room floor a minute ago. Why do you, if you can recall, why did this issue get to the cutting room floor and not make it into your ultimate grounds for appeal?
I think this was one that, while I see what Edwards wrote, and that was really what kind of clued me in that there might have been some other issue there. I thought that the better grounds for that objection were the ones that Lee stated. Relevancy is kind of weak, but if we're saying, look, he can't possibly know what Mr. Davis was thinking when he said this, I thought that would have been I thought that was a better issue. I think when I actually typed up the motion for new trial, I put that in as a judge, you got this wrong, as opposed to we made the wrong objection.
Okay. And I'm assuming by the fact that you objected, you didn't want the jury to hear as evidence that someone believed that your client sounded desperate when he was talking to someone related to the outcry, did you?
Absolutely not.
Okay. And why is that? I mean, this is kind of nonsense of a question, but why is that? Why didn't you want the jury to hear that?
It seems to be almost a tacit admission of guilt.
Okay. And so if there had been a grounds that could have kept this out, would you have wanted to have kept this evidence out?
Absolutely.
For the court, I'm moving now to ground 6. Do you recall there being an issue with? Okay, first of all, did the outcry witness's mother ever testify in this case?
I don't believe so.
Okay, and that would be Katie or Kathy Hayden, is that right?
Yes.
Okay. Do you recall there being an objection during the course of the trial about hearsay from Katie or Kathy Hayden related to the outcry?
I thought there was, because I know that I thought there was an objection made to it, and that essentially it was kind of ushered away because the state said, well, she's on the witness list, she's going to testify. And for whatever reason, she didn't.
So this was a situation where there's a hearsay objection. The state's response is, well, she's on the witness list, she's going to testify, so she'll be available. Is
Yeah.
that, and then ultimately, based upon this proffer from the state, the judge overruled the objection. Is that basically how that happened?
Yes, sir.
And did ultimately, when Katie/Kathy Hayden did not testify, did either you or Mr. Sexton go back and say, well, look, I had this hearsay objection earlier in the trial and she never testified, and so therefore this really is hearsay?
Um, in rereading the transcript, I don't believe that was ever done. And in going back to the trial, I know it wasn't done. I think we were kind of caught up in the heat of the trial and missed that.
Okay. And the statements that were kind of gone into, would this have been Kathy being on the phone talking about text messages that were incriminating that she was seeing during the course of the phone call?
Yes.
Okay. Would you have wanted that hearsay to have come in if you could have stopped it?
I mean, we didn't want any of the text messages to come in. So, I mean, any of them whatsoever, but these specifically we wouldn't want them.
Okay. And was there any strategic reason why the defense did not go back and revisit this issue when ultimately this witness did not testify?
No strategic reason. We just missed it.
Okay. Counsel, now moving to ground 7. Do you recall whether or not the state had any experts who testified about any psychological or psychiatric experts that could have diagnosed PTSD, anxiety attacks, panic attacks, depression, anything of that nature?
I don't believe that they called anyone that was tendered as an expert. I may be wrong, but I don't believe anybody was.
Okay. And so do you recall there being testimony regarding, quote, the entire ordeal and how it affected Geraldine Glass, the victim, including panic attacks, anxiety attacks, PTSD, attending therapy? Do you recall that coming up and there being a relevance objection regarding?
Yes.
And that ultimately that objection was overruled. Do you recall that?
It was.
Okay. First of all, did it occur to you as that testimony unfolded that this was victim impact evidence?
Well, it is victim impact. And, it's also essentially stating the medical opinion.
And to the extent that there wasn't an objection based upon it being improper victim impact evidence, was there any strategic reason that you recall that objections on that ground were not raised?
None.
Okay. And to the extent that it was improper expert witness testimony without the witness being qualified as an expert, do you recall any strategic reason why that objection wasn't raised?
No.
Okay. To the extent that this was objected to on the basis of relevance, do you recall a strategic reason why this issue was not raised on appeal?
Objection,
No.
Your Honor. He can't speak to what was Mr. Sexton's thought process. He wasn't trial counsel. Mr. Sexton was.
Yeah, I agree. I'll sustain that objection.
When this testimony came out during the course of the trial, do you recall if this was a part of the trial where you were present?
It was.
Was this a situation where it occurred to you to tap Mr. Sexton on the shoulder to ask him to object?
Oh yeah.
I'm sorry?
Yes.
Okay, and then he objected to relevance, correct?
Yes.
Did it occur to you to say, hey, Mr. Sexton, this is also victim impact evidence?
I think I told him it was medical testimony. I didn't say victim impact.
Okay. And is there any strategic reason why you didn't raise anything related to this evidence on appeal, or you didn't ask Mr. Sexton
Same
about
objection,
raising?
Your Honor.
Well, Your Honor, I think he was involved in the writing and the drafting of the brief of appellant and the motion for new trial. So I think this would be relevant to ask him.
All right, and the question again, restate the question, please.
Is there any strategic reason why, or is there any, I asked him to speak about the reason why this issue was not raised on appeal.
Yeah, he's an attorney. I mean, he's involved in the case. I'll let him answer the question.
Strategic reason, no, I don't have one.
And then finally, I'm going to move to ground 8. I'm going to read out issues that were raised. And did you have a hand in crafting the amended motion for new trial in this case?
Yes, sir.
And what was your role in crafting that pleading?
I drafted it.
Okay. Do you recall drafting and raising the court erred in sustaining the state's objection to testimony and cross-examination of Cynthia Glass relating to the truthfulness of the complaining witness?
Yes.
Do you recall raising the court erred in preventing cross-examination of Cynthia Glass as to her knowledge of specific instances of untruthfulness of the complaining witness?
Yes.
Do you recall raising the court erred in sustaining the state's objection to testimony and direct examination of Kelly Davis relating to her doubt in the truth of the allegations?
Yes.
And do you recall the court erred in admitting irrelevant testimony by Kelly Davis regarding her opinion on secret keeping?
Yes.
And do you recall raising the trial was fundamentally flawed due to erroneous and misleading jury charges?
Yes.
In the brief of appellant, do you recall why these issues, well, first of all, do you recall why these issues were not argued at the motion for new trial hearing?
I couldn't tell you. I have no idea why it wasn't argued.
Did you think these were meritorious issues when you drafted the amended motion for new trial?
I did.
And in drafting the brief of appellant, can you speak to what strategic reasons might have been behind the abandonment of these issues?
Abandoning the issues.
Yeah.
Well, I mean, we had raised them, so we'd still legally be able to. And in the original draft of our appeal, a lot of these were included. As far as what got sent, they were not included.
And do you know, and do you know why why they were not included?
Lee and I had discussions about what would be better. And Lee had always, you know, and many of the things that Lee was really, really good at, a lot of it didn't necessarily fall on, casting a wide net. Lee wanted to, in most things, kind of center on one or two really big issues as opposed to just trying to pile in. And that's the only thing that I can think of. I know that he and I both thought the strongest issue for the appeal was the jury verdict, because that's one of the things that we discussed at length. Um, essentially the Allen charge before they started deliberating is what we had kind of equated it to. So I know that was what we wanted to focus on being the biggest issue, and that was the one that I spent the most time on researching when we drafted the appeal.
And I believe that we talked a moment ago, but that the appeal ultimately was filed late. The brief of appellant was ultimately filed late in this case.
It was.
Okay. Do you think that time pressure might have had some influence on what issues made it into the brief of appellant and which ones didn't?
I can tell you that
Objection calls for speculation. He
Yeah,
doesn't know.
Well,
I'll let you respond, counsel.
yes, sir. I can tell you that
No,
leading up
I'm
to
sorry, I'm talking,
it.
respond to the objection.
The other counsel, sorry.
Yeah, I'm sorry.
I'm sorry. I thought you were speaking to Mr. Moody as well.
No, I mean, he raises a good point that it's a lot of speculation there.
Your Honor, I'll move on to the next issue.
Okay, all right, thank you.
Were you present during the state's closing in this case?
I was.
Do you recall, or I can certainly show you in the transcript, but do you recall Mr. Van Meter saying that the jury, quote, had a duty to think about Jurlin?
Absolutely.
And keep, is what do you recall about that argument?
Um, if I remember correctly, I think it was almost like the last thing he said. It was kind of one of those, we're here at the end, let me end on a high note. But I remember hearing it and essentially my jaw dropped on that one. That was one that really stuck out to me.
Why did you think it was a proper argument?
God, no, telling them to, think about the victim as opposed to think about the case.
Do you know that there's I mean, are you familiar with a common jury charge about the jury not basing their verdict on sympathy?
Yes.
Was this an issue that would have prompted you to tap Mr. Sexton on the shoulder to try to get him to object to that argument being improper?
Yes, but I can tell you exactly why I didn't, because it was when Jordan sat down immediately after saying that, and it's kind of the end of the case. We didn't want to make the jury, hear that again when that was the last thing he said.
All right. And was this something you discussed with Mr. Sexton?
It was one of those. I tapped him and he waved me off.
I believe, Your Honor, those would be all the questions I have for Mr. Moody.
All right, Mr. Peters, you can ask your questions at this time.
Your Honor, may I have a moment to confer with co-counsel?
Sure, that's fine.
Thank you. Mr. Moody, can you give me a little bit of your background and experience at the time of this case?
All right. Graduated law school in 2010. Prior to graduating, I'd been a intern at the district attorney's office in Butts County under the Third Year Practice Act. The second semester of 2008, all of 2009, and while awaiting bar results in, I guess it'd have been October, up until October 2010. So I had been practicing to an extent for the last 2 years prior to taking and sitting for the bar. After I got bar results in October 2010, I started with Lee November 1st, 2010. As soon as I got results, I left DA's office, went and worked with Mr. Sexton, and have been there since. So when this case occurred, I'd say I'd been practicing almost exclusively criminal defense for at least 3.5 years. I say almost exclusively in that probably 10% of my practice includes domestic issues as well.
So at that time, had you done or performed any jury trials
No, absolutely.
at the time of petitioner's case?
Yeah, yes, sir.
And,
Do you know-
excuse me, when the case was tried, when, in 13?
I think so.
Yes, Your Honor. Mr. Sexton entered an entry of appearance in early 2011. So
When was the case actually tried?
2013.
February the 4th of the 7th, 2013, Your Honor.
Thank you. You may continue, Mr. Peter.
So how many months had you worked with Mr. Sexton before he entered an entry of appearance in this case?
Started with him November 1, 2010. So just hearing the date that the entry was filed, I'm guessing that was about 5 months.
5 months. What was your role in this case? Like, I'm just trying to understand your relationship with Mr. Sexton and your role in petitioner's case.
Yeah. When Mr. Davidson family first came in, I actually participated with our initial interview with them. So then we met with them, discussed what was going on. Like I said, it was a multi-jurisdictional issue from the beginning. So I mean, we knew that there was going to be some stuff to sort out. So I mean, my role from the beginning started out was meeting with everybody, and then from there, much like your typical attorney would do, you start gathering evidence, trying to negotiate a case, see if we can't work something out, short of going to 7 separate trials. And I know that prior to actually starting the trial in Spalding, I'd personally negotiated with 2 other jurisdictions that, whatever happened in Spalding, they would follow suit. So I participated in that regard.
Okay, so you did basically intake, you found witnesses, and you gathered evidence. That's what
yes.
That was your role in the case?
That was part of it. Yes. I mean, I in our practice when Mr. Sexton was still alive, prior to his passing, we had changed the name from Lee Sexton and Associates to Sexton and Moody. We had become partners. At the time, it was Lee Sexton. When this case happened, it was still Lee Sexton and Associates. I was the lone associate. But what we did, any case that came in, both he and I worked on throughout the case in its entirety, whether it was going to be him that tried it or I that tried it. If the case was in our office, it was our case.
When did you become a partner with Lee?
During the height of the pandemic.
In the pandemic, so a year ago?
Yeah.
Did you yourself ever file an entry of appearance in this case?
I don't believe that I ever filed a personal entry on this.
So, okay. So what was
I
your
know
role?
that I appeared.
So what was
I know
your
that
role?
I,
You
I'm sorry, go
appeared.
ahead.
No, you finish. Go ahead.
I know that I appeared in at least 3 of the jurisdictions that Mr. Davis was dealing with personally and made announcements, or I know I tendered the plea with him in Houston County, but I know that I had appeared in at least 3 of the jurisdictions and made announcements on the case, um, argued motions on those cases.
But not this one.
Uh, I know I appeared at calendar call with this one, um, and initially the calendar call on this one, prior to it actually going to trial, I had objected. Well, not objected, had announced not ready, and then Lee made the objection prior to beginning trial, because that was right after Scott had gotten picked up and we couldn't get to him.
Concerning trial, what was your role during the actual trial?
During the actual trial, my main responsibility was organizing and making sure our witnesses were there, and making sure that he had exhibits to put up to the jury.
So,
That was my main role.
so more of an administrative function?
And in this trial, yes.
Okay. What, um, were you sitting at the table with Mr. Sexton during the trial? At any
Yeah.
point?
Oh,
Which
yes.
point?
During voir dire, I know I was there during voir dire and the closings. I was there. I know when the alleged victim testified. Um, Essentially, the only time that I know I wasn't in the courtroom at the table, was when Lee was putting up defense witnesses, because I was out in the hallway trying to get them in order. And there was another point in time that I had to leave during a state's witness to get. I think I had to pick up a witness, but I know that that was only like a 2-hour block.
So, did you examine any witnesses?
I did not.
And which witnesses were you present at the table with Mr. Sexton? Which witness testimony did you observe or did you participate in?
And specifically, like, I know I might have, like I said, I only missed about 2 hours of the entirety of the state's case, and that was going to pick up a witness that was at the airport. But other than that, I was present during, specifically during the alleged victim's testimony, and during her mother's testimony, and during the investigator's testimony. I specifically remember those. But I mean, honestly, I was there mostly for the entirety of the trial. There was only a very short block that I wasn't actually there.
Okay, but you had no role in examining any witnesses.
I did not personally examine any witnesses.
Okay. And so what was the issue that Mr. Sexton raised on appeal?
That the jury instruction as delivered was inherently coercive and fatally flawed the verdict.
May I have a quick moment, Your Honor?
Yes, sir.
Thank you. No further questions, Your Honor.
Okay. Mr. Moody, I do have a question. I'm trying to understand your previous testimony about your client being unavailable because he was not incarcerated in Spalding County.
Yes.
Do you recall where he was incarcerated?
I don't offhand. Like I said, I mean, this was a multi-jurisdictional issue, and I don't remember specifically where he was. I do remember wherever it was a place that we either didn't have access to speak with him, or it was somewhere that we couldn't get to. I mean, I'm not saying that it was at the North Pole or something like that. I just know that it wasn't.
Well, it had to have been in Georgia,
Yes.
I would think, in some reasonable proximity to Griffin, correct?
Yes, sir. I mean, like I said, I don't remember specifically.
So-
I do remember we attempted to get visitation at the location, and that for whatever reason we were denied or were otherwise unavailable. And it may have had. I'd like to say it had something to do with the transport rules and production orders and stuff along those lines. Because I mean, he got picked up relatively close in time to when he would need to have been in Griffin for the trial, and for whatever reason, we couldn't get to see him prior to him either being moved or something happening along those lines.
Why couldn't you or Mr. Sexton just travel to the jail where he was incarcerated and speak to him there?
I remember we tried that, and for whatever reason, we were denied ability to see him because
Denied by who? They can't deny you from seeing your client.
well, we got there and they told us he wasn't there because Lee and I went to a jail together. I don't remember what county it was, but we went together and were essentially said, your client's not here anymore. He's been moved.
I mean, do you recall where he had been moved to, or?
They told us they were taking him to Spalding, and we got to Spalding and he wasn't there. Thinking back on it, I think that I'd like to say this was at the Upson County Jail, but I mean, I can't say for certain. Wherever it wasn't very far from Spalding because we were able to get to Griffin pretty quickly. And they're like, well, he's not here either. We don't know where he's at. Because we tried to talk to him before this, and that was the reason why we made the objection prior to trial.
Just the one attempt to talk to him, or were there other attempts?
Prior to going to trial, we had some pretty good contact with Mr. Davis. As far as specifically, I don't have a specific memory of when he got picked up in the other jurisdiction prior to this trial. So I don't know. I don't know that exact timeline, and if Lee tried to speak with him another time or what. But I know that I personally rode with Mr. Sexton to the jail at least the week before there was the trial was supposed to happen, and we were told he wasn't there anymore.
So you made the one trip with Mr. Sexton, but you don't know what attempts Mr. Sexton may have made on other occasions.
I do not.
Okay, fair enough. Fair enough. All right, any follow-ups, counsel, or?
I have no follow-up, Your Honor.
All right, then, Mr. Moody, thank you for your testimony. Have a good day.
Yes, sir. You do the same. Y'all have a good one.
Mr. Key, do you have another witness or any additional evidence?
I have no other witness. Depending upon what the warden offers in rebuttal, I may wish to keep the record open for further exhibits, but at this time, I have no other evidence.
All right, Mr. Peters, what do you have to offer?
I have 10 exhibits. And let me share my screen. Can y'all see that?
Yes, sir.
Yes.
So R1 is the appellate index. R2 is the record. R3 is trial transcript volume 1. R4 is trial transcript volume 2. R5 is trial transcript volume 3. R6 is trial transcript volume 4. R7 is the motion for new trial hearing transcript. R8 is the brief of appellant. R9 is the brief of the appellee. And R10 is the unpublished Court of Appeals decision.
All right, Mr. Key, any objections to any of the exhibits?
No, Your Honor, no objection to those exhibits.
All right, respondents exhibits 1 through 10 are all admitted without objection. Anything else from the warden?
The only other thing is the death certificate of Lee Sexton is in the mail and should be arriving within the next day or so, if I understand that right. If you want to, if we could ask to leave the record open and make that a part of the hearing when we get it, or the transcript when we get it. Yeah, would you like to do that?
Any problem with that, with Mr. Key?
I have no problem with that, Your Honor, and I would ask that the record be left open so that I may tender the notice from the Court of Appeals regarding the untimely brief of appellant.
Any objection to that, Mr. Peters?
No objection.
All right, so we're gonna leave the record open specifically to include 2 additional exhibits. 1 exhibit from the warden and 1 exhibit from the petitioner, which have already been identified. So you both agree to that?
Yes, Your Honor.
Your Honor.
Okay, and once those exhibits are tendered and made a part of the record will then be closed. All right, anything else, gentlemen?
And may we then have the opportunity after the record is closed and the transcript has been produced to then prepare a brief in support of and of course a brief in opposition to habeas.
Absolutely. I don't require that. It's not mandatory, but counsel, I'll be glad to review and entertain anything you submit.
Thank you, Your Honor.
Yes, sir. And same for you, Mr. Peters.
Thank you, Your Honor.
All right, gentlemen, thank you. That'll close the hearing.
All right, thank you so much. May I be excused?
Yes, sir.
Where would you like us to send the exhibits, Judge?
I've got the staff attorney on board. She would be the one who would better able to answer that question.
Sorry, sir. Eric, I'll email you her contact information.
Okay. That sounds good. Thank you.
All right, and Mr. Peters, what would be the next case?
I think that's it for the calendar today.
Okay, well, that's unusually short.
There were a lot of motions to transfer and a lot of continuances.
Oh, I saw some of those. All right, then. Well, have a good day, and hopefully we see you in person next time.
Yeah, Judge,
Or Miss Smith, you're never coming back, right?
No, I was going to, I actually have a federal hearing in the morning with Judge Christopher Ray in Savannah. And they did the imperial notice yesterday at 10:05. Oh, we're going to have a test run at 10 o'clock in the morning. So I've been stepping in and out, but I've been here trying to whisper and nudge Mr. Peters, Eric, as if I was at council table. But I do hope to see you in person.
Well, it's always good to see and talk with you, and good luck before Judge Ray. He's a new judge. He's a really nice guy.
Is he?
Yeah, you'll enjoy Chris. Good guy.
Wonderful, wonderful. I appreciate that because nobody else has. So
no, Chris was in the military, and he was a JAG officer, and then went over to civil firm over in Savannah, and just a real gentleman.
Oh, well, good. Well, I appreciate that because I just, the worst thing you want to do is misstep right out of the box. So.
No, you're in good hands, and he's in good hands too. So.
Well, I thank you, Judge.
All right. Well, y'all take care. See you soon.
Good to see you.
All right.
Miss Rachel.